All right, we're going to begin in a few minutes. And I just wanted to let everybody know I put a message in the chat. If you've got any questions, go ahead and type the question in the chat, and we will address that at the end of the presentation. Assuming we have time, I think we should have time because I'm shooting for an hour-long presentation with a half-hour question answer. Alternatively, if you're watching a replay or watching a recording of this, you could still put your questions in the chat, and all of those questions are emailed to me directly, and I will be able to respond to them, assuming you provided your email at registration. If you didn't, go ahead and put your email in the chat, the chat area there, and I'll respond to your email. The chat's completely private; only I can see it, so you don't have to worry about other people getting your personal information. All right, guys, let's go ahead and start here. I'm happy to be here on a wonderful evening to talk to you guys about family wealth protection and preservation. We're going to focus tonight on really protecting your children, in particular your minor children. So if you've got minor children, you're thinking about having children, this whole presentation is geared for you, because what we're going to learn today is what would happen in the event of your death while your children are still under 18. What the plan is, what the state of California's plan is for you, and what you can do in the event, in the very likely event, that you don't like what's going to happen. So let's get into it. I put in the chat there that if you got any questions, go ahead and put them into the chat. I've made the chat completely private so that only I can see the chat. So if you've got any questions at all, maybe you feel embarrassed, just type them in the chat. Only I can see it, and that way I can respond at the very end of the presentation. And if we can't get to your questions, all of the content in the chat is emailed to me, and I'll be able to respond. So with that in mind, let's start with a little bit about me. All right, who am I? Why should you listen to this guy talking? Well, whether you should or you shouldn't, you are listening to me. But here's what I've done. I've been doing estate planning for 10 years. Ever since I got sworn into the bar, the very first thing I started doing was estate planning. I was doing litigation and doing other things. I did construction, and I did all sorts of other areas of law. But the one area of law that has been a constant in my 10-year career has been estate planning. Before doing estate planning, I was an expert for the Vatican at the United Nations, which was a phenomenally fantastic experience. And although we don't have time for it in this webinar, I've got a great story about Nicolas Sarkozy and Angela Merkel. Just to kind of wet your whistle a little bit, the way the United Nations work is at the General Assembly, every state is assigned a seat, and it rotates every year, except for the Vatican. The Vatican has the same seat year after year because it's a non-voting member. Although the Vatican is a state, it's a non-voting state because it chooses to remain non-voting. Anyway, so it stays in the same spot, but the countries move around it. And this particular year that I was there, Nicolas Sarkozy, France, was sitting directly in front of me, and Angela Merkel was 2 seats down. And so I've got a really great story about the both of them, but we don't have time for that. But I just wanted to kind of tease that. So if you ever do, come in for a consultation or something like that, remind me to tell you that Nicolas Sarkozy and Angela Merkel story. I'm the owner of Regnum Legacy, which is a law firm that I founded to really address a gap in the estate planning world, the way lawyers are thinking about estate planning. And we'll get into what Regnum Legacy is in just a little bit. And most recently, I'm the winner of Avo's Client Choice Award for 2020. They just told me this about a month ago. And if you don't know what Avo is, it's an attorney rating platform, and they assign a rating to attorneys and give awards based on objective criteria. It's also a legal forum, so if you've got questions, you can type questions in the forum and attorneys can answer it for you. But I was named the Client's Choice Award for 2020. All right, so I mentioned I founded Regnum Legacy, and I'd like to tell you a little bit about what Regnum Legacy is. As I said, I was doing estate planning for about 10 years, and I was doing things probably the same way 80% of the attorneys out there are doing it. And basically, the way 80% of attorneys do it is you come in, you tell me about your family, I produce a set of documents, I give you the set of documents, and you go on your way, and now you've got your plan. And the problem with that is I started noticing in the litigation part of my practice that there were significant problems there. I'm a little bit unique because not only was I doing estate planning for 10 years, but I was litigating cases, which meant I was a trial lawyer, prosecuting cases or suing people or defending people who were being sued. And a lot of those cases were cases involving trusts, essentially failed estate plans where something went wrong. And I started noticing a certain trend among all the litigated cases. And in almost every single case, there was a period of time where the estate plan was done and then something happened after to make it all break down. And I'll give you an example. There was a case that I litigated. The mom had an estate plan drafted about 20 years before she died. The estate plan was drafted. She had about $2 million of assets. And over the years, she started drafting amendments by herself. She didn't either want to go to her old attorney or didn't know she could go to her old attorney. The point is that her attorney had no existing relationship with her. And so she amended her trust, and she amended it in ways that were very confusing. So on her death, the family fought, and they fought. And my firm was one of those firms that were caught in the middle of that, and it was a 9-year battle involving 7 different attorneys for 7 different parties. And by the end of it, that $2 million estate was eaten through. The lawyers got everything, and the kids got just a few $1,000s after they were done fighting. And it could have been avoided if there had been an ongoing relationship with that family. And so it was things like that where I started seeing, wait a minute, does this make sense? And in fact, I started looking back at the estate plans I was drafting because I was worried that I had committed malpractice. Am I not following up regularly enough with my clients? Are my clients' plans still valid? Are they still good if the law has changed? And I called the ethics hotline. I talked to numerous other estate planners. And what I learned was that far from being malpractice, that way of doing things is common practice. It doesn't mean it's good practice, but it's not malpractice. It's not bad practice. It's just how it's done. And it didn't sit right with me. So I knew I had to do something different. So I started Regnum Legacy. And I'll tell you about other reasons why I started a little bit later. But Acquisition International named us the most innovative estate planning law firm in 2020. And Lawyers of Distinction actually awarded us an award for excellence in estate planning law. And so even though we've been around a relatively short time since I founded the company, a lot of people are taking notice because frankly, the way we're doing things and the way we're protecting families is completely different than a lot of other lawyers. So with that said, I'd like to share a video with you. Oh boy, I'm gonna do this wrong, I know it. Hold on here. Family, being a father, fundamentally changes how I view the world and how the world views me. And I think that's why family is so important, because that relational aspect between you and other people is fundamentally changed, in my view, for the better. For us, legacy is not just about what you have, it's about who you love and what you love. Ultimately, the goal for my firm is to make sure that the plans that we're creating for our families are plans that are both going to work and keep their families out of conflict. You can plan for life, but you can't plan for the unexpected. And that's why having an estate plan and engaging in estate planning is necessary.
For us, family is everything. Family is central to who we are. For our children, I think it's very important that they have that opportunity to build a future for themselves. Nobody can guarantee tomorrow. Nobody knows. And so I think it's good to be ready, to be prepared. And this is a big part of the estate planning. We have just felt so much better since making the decision and moving forward with the planning. You've got somebody who's a professional, this is what they do. I mean, when you're sick, you go to the doctor. And when you're preparing some type of estate plan like this, you go to an attorney, you go to somebody who knows. James understands families. I think he also understands taking care of one another. I think that's very important. I think that's all part of this process, is that we take care of one another, and that's what families do. And James knows that. He gets it here. And he's a very sharp guy here, so that combination will take you where you need to go.
Ultimately, my firm's main goal is to make sure that families are protected. Every family who comes in is getting not only the estate plan that they need, but is getting the life and the peace of mind that they want. At Regnum Legacy, our promise to our clients is that you're going to get not only the best legal service and the best legal minds working for you, but you're going to get lawyers who understand you, who understand the importance of family, the value of family, and who are going to do everything to serve you first. We're not here for a transaction. We're here to be your family lawyer. All right, so that's a little bit about who my firm is and what my firm is. And the thing that I want you to keep in the back of your mind is we're here to be your family lawyer. And that's going to be fundamentally different when we talk about how to protect your kids and how to plan for protecting your kids, because the way we plan and the way my firm thinks about planning for young children is so much different now that I have kids. I have a 2-year-old and 3-year-old. And now that I have kids, the way I think about estate planning is just so different. And so keep the family aspect in the back of your head, because that's how I've created this firm. So let's get started here. I'm going to ask you a question, and I'd like you to take a deep breath before you even think about it, because as a father and as a husband, even as an estate planner who does this for a living, it's hard for me to think about. But I'd like you to think about it for just a brief moment as we begin. Picture you're out on a date with your spouse, your kids are with a babysitter, and on the way home, you and your spouse die in a car accident. Who would take care of your children? Who's going to be there? Even as I say those words, I don't even want to think about it. I can't comprehend it. But I know it's a possibility. And one day at a date with my wife, I thought about that. And we had left our child, or our 2 kids. We have I said a 2-year-old and 3-year-old, but at that time, I think Nolan was about 9 months and JT was just 2 or about to turn 2. And we left our children with a babysitter. And we usually leave our kids with either grandma and grandpa or auntie and uncle, or aunties and uncle. We only have the one uncle. But this time we left them with a babysitter. And I remember thinking, if something happened to me and Vanessa, would the babysitter even know what to do? We didn't leave anything behind for this particular babysitter. Who should they call? And so it got me thinking, who would care for our kids? And so that's where we're going to start tonight, is really thinking about who would be there to care for them. And we're going to talk about what care means. And in a moment, we're going to talk about the two different kinds of care you need to be thinking about. There's short-term care and there's long-term care. And let me explain what that means, because you need to have both in order to protect your family. Short-term care is that moment when an accident or tragedy happens, okay? When an accident or tragedy happens, and immediately someone can take your children and care for them until the next step, all right? Now, as I said, if your kids are home with a babysitter, it can't be the babysitter, because the police will not allow the children to stay with a babysitter. If, most of the time my kids are with grandma and grandpa, and if grandma and grandpa are there, hey, that's great. The police would allow, for a short period of time, them to stay with grandma and grandpa until a long-term arrangement can be made. But if you don't have a plan, and if the police can't find family members close by, if there's no one readily available, the police will take your children into protective custody. And that's what happened to the Barber family. This is a story from 2006. It's a true story right here in Southern California. In that case, the Barber family was on a road trip. They ended up getting in an accident. Luckily, all the children survived. But sadly, the parents didn't. And so when the police came and the emergency personnel responded, they had no idea where these children should go. So the children spent those first couple of nights in protective custody. They got to spend the night after they learned their parents had died in the home of a stranger. As a father, I just can't even imagine that. I can't imagine a stranger caring for my child for 1 second, let alone caring for them for an entire night at a moment when they've just lost me. And that case kind of gets a little bit more tragic, because what happened in that case and what really made it, a sort of media kind of story was that ultimately the police were able to find a sister in San Diego, and the kids went to go live with her, and there ensued a 2-year court battle over who should get the kids. The kids lost their parents, and then the family's fighting over them because the parents didn't leave any instructions behind. And the entire fight was over values. It wasn't over this person's unqualified, this person's addicted to drugs. Everyone, at least in the eyes of the court, were equally qualified. And what happened was the family was fighting over who sort of embodied the parents' values the most. And it cost several thousands, hundreds of thousands of dollars, tens of thousands of documents filed in court, and it was just a really ugly battle. So for the short term, what you need to think about is, who's going to care for my children in the short term so they're not taken into protective custody? And then in the long term, what are we going to do? Who are we going to have? Now, apologies if my sister's on this. I know she registered for one of these events. Amber, if you're here, I apologize, but I'm going to use an example for my family, and it's not a true example. So Amber, don't exaggerate this at all, okay? But let's suppose in my family, I've got my sister Amber. She lives in Colorado. That's a true story. And we've got my wife's sisters, my sister-in-laws. They live in California. Now, let's just suppose that I wanted my family to be raised by Filipinos, right? We just wanted my children to be raised with Filipino culture. My wife's Filipino, by the way. I should have explained that. Maybe you could have told it from the video, but we want a person who can embody Filipino culture so that they would be able to foster that part of their culture, that half of their heritage. So I would exclude my sister from that. But on paper, okay, on paper, if a judge was going to decide my sister owns 2 houses, she's a nurse, she's a mom, and she's living a stable life in Colorado, just down the street from my parents. So And Vanessa's sisters are all either in college or just graduated from college. None of them are married. None of them have children. Who do you think the court would side with? Who would you side with? You would side with the stable mom who's done all these, has the houses and everything like that. But it might be inconsistent with my values. And you might have something similar to that. Maybe you've got religious preferences and one family member is perfect and one family member is not. Maybe you're a really devout Catholic, but you've got a sister who's just atheist or anti-Catholic or converted to be an evangelical, and maybe thinks Catholics are going to hell. I don't know. But the point is that person would be the last person you would want to raise your children, because what we're really talking about here isn't who's going to care for your children long term. We're talking about who's going to raise them, who's going to instill their values going forward. And unfortunately for the court, if you don't, unfortunately for you really, if you don't make those values known, and if you don't make your wishes known, the court's going to decide. And the court doesn't care about religion. The court doesn't care about values. The court cares about, are they stable? Do they have money? Are they responsible? And those kinds of things. And we've seen from this example, and you can think of others where that just would not mesh with what you would want. So in most cases, the person who a judge would pick is probably a person you would not like raising your children. You might be okay with them caring for your children for a while, but raising your children and instilling your values is probably something you wouldn't like to do. And the only way to really fix that is through proper planning. All right, now let's talk about, we've talked about the short-term and the long-term process that you need to think about for your children. Everybody has sort of an estate plan and a plan in place for where the kids would go. Like I mentioned, the judge will decide, and that's going to happen through a process called probate. We'll get into what probate is in a little bit, but for now, understand that on your death, if you don't have any kind of will or a trust or some sort of document left behind, the courts are going to have to decide. And moreover, what's going to happen to your estate is all of your assets are going to go to your kids. And if they're a minor, they can't control the assets. So they're really going to go to whoever the court picks as a guardian. So, if you're worried about a particular relative or something squandering money, you want to be sure that that person is never able to be the guardian of your children, even if they're really great parents. But if they're not financially responsible, they're going to be the one managing your children's inheritance until they turn 18. And we'll get into why that's a bad idea in a second. That is why it's a bad idea to have a child inherit something at 18. But for now, just understand that there's a whole probate process. And so initially what would happen is the process would be open. It's super long, right? There's a picture there of a guy with the snail. It really moves at a snail's pace. I've been a probate lawyer. I filed probate petitions. These things take a long time. And particularly now when the probate court shut down because of COVID, they're so backed up. It used to take, 12, 16 months to get through a probate. I mean, I'd expect it to take at least 2 years now with all the backed up systems with the court. And that means for 2 years, you've got your entire estate sort of locked up. And if in the meantime, your kids need to go to college, maybe your kids need special care, special treatment, maybe they need therapy after being traumatized through as a result of your death. Those expenses are things that the guardian would have to pay for, but they couldn't access your estate because it's stuck in the probate process. So let's talk a little bit about what probate is. This is your default estate plan, by the way. We're talking about young children, but this probate process is really the default. You already have a plan, even if you don't have a formal plan, and it's the state's plan for you. Now, the probate process, the technical term for it is a legal procedure that a court gets to decide, I should say, a legal procedure by which a court decides where property goes after someone dies, or who gets to care for someone if they can't care for themselves. For example, minors aren't allowed to care for themselves, so the court has to appoint a guardian. If you were incapacitated and you didn't have a plan, a court would have to appoint a conservator or a guardian over you because you couldn't care for yourself. And that's only if you don't have a plan, so the state has one for you. But here's a better definition, and it's more accurate. It's from a lawyer friend of mine, so it's not mine, but I borrow it all the time. I just realized my video is covering part of it, but let me read it to you. Probate is a lawsuit you file against yourself. Okay, it's a lawsuit you file against yourself with your own money for the benefit of your creditors. I'll say it again. Probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. Probate is not about, getting your beneficiaries your property. It's not about, caring for your children. What it's really about is making sure your creditors get paid. That's why it takes so long, because the court has a whole procedure to make sure the creditors have enough time to make claims on the estate. All right, so that's what probate is, and that's why you want to avoid it. There's some other reasons too, but really, it's just a mess. This is Anna Nicole Smith's last will and testament. Incidentally, her real name was Vicki Lynn Marshall, if anyone cares or remembers that. But the reason I put this up here is Anna Nicole Smith died without a trust. She died with a will, but what I'm underscoring here is that the probate process is entirely public. I can get access to Anna Nicole Smith's will because anytime somebody dies and they don't have a trust, it goes through the probate process, and that's an entirely public court proceeding. I can go and sit not right now because it's late, but tomorrow when the courts open up, and you can too, go down to the courthouse, to the probate court, and just sit. And you can listen to everybody's dirty laundry being aired. You can listen to who's getting what money, what property is being distributed, what property is being sold, what property is being bought. You can hear all sorts of things, and it's all public record. That's how we have the last will and testament of Anna Nicole Smith or Vicki Lynn Marshall. Same thing with Jackie Kennedy Onassis. Jackie Kennedy's will is public because it's not a private process. So if privacy is something you value with your children, you don't want to be in the probate process. All right, here's one of the worst things I think can happen to children. They get assets when they're 18 and unprepared to have it. Now, if you go through the probate process, and if you've done a trust on LegalZoom or Rocket Lawyer, or you've used the discount lawyer down the street, you probably don't have protections in place to actually protect your children from themselves, protect your children from future divorces, judgments, creditors, bankruptcies, all sorts of things. And I want you to kind of step back and think back to when you're 18. I'm going to do it too. If I'm thinking about my 18-year-old self receiving several $100,000 at age 18, what would I do? And more importantly, would I be ready and responsible enough to handle that? And I don't even have to really think about it. I already know at 18, hands down, I was dumb. I did dumb things, and I would not have responsibly used that money. I don't think I would have been responsible enough until I was in my mid to late 20s, to be honest with you. And that's true for a lot of people. It's true for some adults. There are adults in their 40s and 50s who just are not responsible with money. And you need to know as a parent that there are options to protect your children, not only from themselves, but from future spouses. Because here's what's going to happen. Your child is going to receive an inheritance. Whether they die or whether you die when they're minors or not, they'll receive an inheritance at some point. And if that goes outright to your beneficiaries, that inheritance is theirs. It becomes part of their estate. And that means if they get divorced from their spouse gets half. If they have a judgment against them, that judgment creditor gets your inheritance. If they go through bankruptcy, the bankruptcy trustee takes the inheritance. You get the picture? If they develop a drug habit, guess what? They inject it into their veins. And this is particularly troubling with children, because at 18, if you don't have a plan in place, the court is going to give your estate to a guardian. And at 18, the guardian's going to cut a check to the kids. And that's a bad idea. And here's why. This is Christine Paolilla. And I said a cautionary tale because it's a true story. I got this story from Forensic Files, by the way. It's on Netflix. I love that show. And I was listening to it, and I've seen this particular episode probably at least 3 times. But I had caught just sort of in passing this particular portion of the story, and it caused me to go and look it up. And it really is a cautionary tale. So this is Christine Paolilla when she was about 18 years old. You can see that's her on the left of the screen. That's her senior picture. And then I think in the middle is her high school graduation, and that's her and her boyfriend at Christmas time. Now, by all outward appearances, all-American girl. She's beautiful. She's got everything going for her. And I mean, probably, maybe except for a few differences here and there, probably is just like your kids. Has boyfriends or girlfriends. They have ambitions. They're just normal kids. But what happened was, after Christine graduated from high school, her dad died. And her dad, although her dad had a trust that was drafted by an attorney, the trust did not make or did not set any provisions to protect her. So what the trust did was say, give everything to my daughter outright. There were no restrictions. There were no conditions. She just got a check. And I think the check was for something in the neighborhood of $300,000. So here's this 18-year-old girl, Christine, and maybe she was 19 by the time she got the check. But this 19-year-old girl gets this $300,000, and I'm not kidding you, 9 months later, 9 months, this is Christine Paolilla, 9 months after she got the inheritance. These are her arrest photos for quintuple homicide. 9 months later, the picture in the background, you can see the needles and the Marlboro package and the Cheez-Its box. That's actually a police photo from her hotel room where they found her. She was locked up in a hotel for 9 months, shooting heroin, smoking cigarettes, and eating Cheez-Its. That was her life. And when the money ran out, the $300,000 ran out, she went and robbed someone and ended up killing 4 people. Now, this is an extreme story, okay? This isn't an episode of Scared Straight. I'm not trying to scare you into hiring me or anything, but what I want to underscore is stuff like this happens all the time. As a lawyer and as a litigator, I've seen it happen. I've seen it happen to adults. This is not unique to an 18-year-old. Any person who is susceptible to influence, who is not financially responsible, or just isn't in a space emotionally and mentally and physically to handle a large sum of money all at once, is going to make bad choices. And unless you build special provisions into your trust to protect your beneficiaries, and in this case, your children, bad things can happen to them. And, it's not just drug use. They could be taken advantage of by people who want to, have them invest in a business. I've seen that happen. Inheritance is completely lost by fraudulent business practices. Somebody asking them to invest in a business that doesn't exist, and they're not savvy enough to know otherwise. And then I've got to I'm hired to track down that money. I've seen it happen. So it's not just drug use. It can be a whole lot of different things. But this is why you need to be proactive in your planning. All right, so let's talk about the expense of probate. Let's do this hypothetical here. Let's say you have a family home of $500,000. Maybe you've got a rental property. It's worth $250,000. Or maybe you've just got one home and it's worth $750,000. I don't know. You've got a retirement with some stocks worth $380,000. You got some business interests. Maybe you own a side business somewhere. It's worth maybe $100,000, and you've got some life insurance. All in all, you got $1.7 million. You're going to pay just the probate fees alone to transfer that estate to your children. You're going to pay $60,000. That's just the probate fees. That doesn't count the filing fees, the creditor fees, the bond premiums, any of that. This is just the probate fees. That's it. Now, if all you had was the $500,000 house, you'd pay $26,000 just to get it to your kids. And here's a sad case that I had just, it would have been 4 years ago now. Mom had 4 kids. She left a will. The only asset she had was the home. And her will specifically said that the house is not to be sold because she wanted to retain the house as sort of a central hub for her children to gather in and have Christmas dinners and things like that. And the reason was because this was the house they all grew up in. unfortunately, the children were all college-age students. And so when it came time to pay the probate fee, which was about, at that time, I think it was about almost $20,000, none of them could afford to come up with the probate fee. So what happened? The court ordered the home be sold so that the probate fees can be paid and the kids were able to split the check. But the point is that the mom's intent that the family retain the house was thwarted. The court didn't care. What the court cared was that the probate fees got paid. And so when we're thinking about your estate, you know, it sometimes gets lost in translation that although you're not paying anything up front, your children have to pay those fees later. It's not something that just, you know, gets forgotten about. Your kids will have to pay for it one way or the other, either out of their pocket or through selling your valuables. All right. Now, here's the only foolproof way to avoid probate, and really the only foolproof way you can actually protect your children. And it's to have, you might have guessed it, a fully funded living trust. I'm going to underscore that fully funded part. That's why I put it really big font there, a fully funded living trust, because you can get a trust from any lawyer down the street. Any Joe Schmo lawyer can give you a trust. You can get a trust right now on legalZoom for $300. The question is it going to work? Is it going to do what you need it to do and protect your family? And it's only going to do that if it's a fully funded living trust with specialized provisions that account for your unique wishes. All right, so what does that mean? It means that you have retitled your investment account. So maybe you've got an estate plan, maybe you've got a trust already. Here's what you need to look for. Or if you're, you know, interviewing lawyers and they're going to tell you, here's what I'm going to do for you, you want to know if the lawyers are going to do this, if this is what you're going to get, or if this is what you have already. Are your investment accounts retitled? Now, I don't mean retirement accounts. There are some circumstances where you'd want to have a retirement account or a 401k or something like that in a trust. Most cases, not. But that's where you want to work with a good financial advisor or a good CPA. I've got a financial advisor friend who's actually attending this webinar. His name's Mark. I don't, maybe if Mark wants, I'll put his information on the chat and you guys can contact him if you need advice or anything like that. But the point is that you want to consult with a financial advisor or accountant if you're going to put a retirement account into the trust. But any other type of investment accounts should go into the trust. If you have bank accounts, like, well, not if, all of your bank accounts need to have new signature cards with the bank. All of your deeds need to be retitled. You need to have new deeds for your home. Your stocks and bond certificates need to be retransferred or retitled and transferred. So that's if you've got a corporation or an LLC for a family business or something, you need to reissue those stock certificates in the name of your trust. Otherwise, that business is going to have to go through probate on your death. You need to assign all of your personal property into the trust. And that's not just a, hey, I assign it. It's a formal legal document that actually puts your cars, your clothes, your furniture, your boat, your trailer, whatever it might be, into the trust. So that on your death, you know, your children can go to the DMV and change the title and they can use it. And then the other thing you should do is for life insurance and retirement accounts, you wouldn't want to necessarily, as I said, put the trust as the owner of those accounts, but you should at least put the trust as the designated beneficiary. That way, everything you own is flowing through that trust. And so whatever provisions you put in for your children are all going to flow through that trust. So if you don't want your kids to get, say, a large chunk of money at 18, you want to wait till they graduate college, you could put a provision in a trust that says they don't get the money till they graduate with a bachelor's degree or you know, graduate from a four-year institution, whatever it might be. And that way, those provisions protect your children and everything flows seamlessly through that trust. This is a little bit on estate tax. Now, the estate tax, if you look at the bottom, the estate tax exemption, that means how much you can transfer for free, is $11.5 million. Most of you are not going to have $11.5 million of assets. All right, that would be a great problem to have. But if you did, if you had, say, $14 million, you would pay 40% taxes on anything over 11.5 million. So in this $14 million estate, you'd pay $1,028,000. Now, if you had a trust on the other hand, your estate tax would be zero. Zero in this particular circumstance. Now, if you had $100 million, you're going to pay some estate tax, right? No, wonderful, beautiful trust is going to prevent that. But if you had up to 20, 30, even $40 million, depending on the type of assets, you can get away with paying no estate tax if you have sophisticated and advanced trust planning. All right, I just wanted to underscore the tax implication there, and the reality is a lot of us aren't going to have that $11 million, over $11 million, but all of us own some kind of property. And if you think right now, think about every piece of property you own, every car, every bank account, every investment account, every piece of stock, every life insurance policy, a funeral policy, everything. If you died right now, would your family know exactly what you own, what institutions hold those accounts, and what the account numbers are? And if the answer to that question is no, you're at a high risk for your estate being taken by the California Department of Unclaimed Property. What is that? Every state has a Department of Unclaimed Property. When someone dies, if the state or somebody can't find the owner, it goes to the Department of Unclaimed Property. So I usually see these kinds of things with, let's say, old life insurance policies, right? A burial policy, right? I dealt with a client the other day, had a burial policy. They didn't even know about the burial policy. Luckily, the insurance company called the family to figure out whether or not it was true the beneficiary had died. But it was a $50,000 burial policy to cover funeral expenses. The family didn't know about it, so they covered the funeral expenses by themselves. But the point is that since they didn't know about it, that $50,000 very well could have ended up in the California Department of Unclaimed Property. If you've got another situation that this comes, I frequently see is sometimes family members will invest in real estate property, right? Everybody's got that chunk of Barstow land that they bought dirt cheap when they were sure that the housing market was going to take off, and Barstow's the boom town. Everybody's got that chunk of land that they bought for $10,000, and it's just sitting there, and it's doing nothing. Well, guess what? Unless you have that asset titled somewhere and someone knows about it, it could go to the Department of Unclaimed Property. And this is particularly true in the digital world because a lot of our bank statements are electronic. They go to our email. How many of you have a digital asset list for all of your family members and heirs so that they know the usernames and passwords for every account that you have? I'm guessing probably none of you. And if you don't have that, your family's not going to be able to get the statements and see what you own and transfer it. So it could go to the Department of Unclaimed Property. Does anybody know how much is in that department right now? The Department of Unclaimed Property for California. Does anybody have any idea? Put it in the chat if you think you know. We'll do 15 seconds in the chat. No one knows. $9 billion. $9 billion. That's with a B. $9 billion. I see, let's see, Mark said that the connection's going in and out. I am so sorry. I don't know how to make that better. This is only our second webinar. Usually we do these things in person, so we'll have to figure out how to do that. It says my signal is strong, though. I don't know what's happening. I'm just going to continue. I apologize if you can't hear me. Please hang in there with me. Please stick with me, and we'll figure out how to protect your family and get this thing going. $9 billion in the Department of Unclaimed Property. That's a lot of money. And it's not just from one person. It's from hundreds of millions of people losing their property to the state of California. Now, what you really need to do with your family and with your estate is make your living trust like a treasure chest. Think of your trust as a chest filled with, all of your valuables. And it's got a lock on it. And at any point, your children can come up to that chest and grab some money out of it. But if they need to, they can lock it down. And why would they need to? They would need to for creditors. They would need to because they've got a divorcing spouse who wants that money, and they can lock it down. Only a living trust can do that. You can't do it with a will, and you certainly can't do it in the probate process with the state. You need to have a living trust with specialized provisions, and you can create essentially a treasure chest for your family to protect those assets for the rest of their life. All right. Now, the final component of an estate plan and why we're going to talk about this has to do with your children as well. This is Terry Schiavo. Maybe you remember the Terry Schiavo case. This was a very devout Catholic family, the Schiavo family, or Terry's family. That's her married name, I think. But Terry was in a horse accident, I believe. She fell off a horse, and as a result of the accident, she was severely brain damaged. Now, contrary to popular belief, she was not in a vegetative state. She could understand what people were saying. She just needed a feeding tube and water to survive. Her husband at the time, after Terry was injured, he met a girl and they became romantically involved. He wanted to remarry. Well, he couldn't remarry while his wife was still alive. So he petitioned the court to have her feeding tube and the water be removed so that so she would die. Her family, who was a devout Catholic, opposed that and said, wait a minute, this is against our beliefs. This is against what we hold true as the Catholic Church. And this is true. The Catholic Church and the Catechism has a specialized provision that says it's immoral to withhold the ordinary means of preserving life. Now, maybe this doesn't mean anything to you if you're Catholic, but if it does, you want to make sure your healthcare directive has something like this, because the Catholic Church has a very specific belief about end-of-life issues. And one of the beliefs is you cannot withdraw the ordinary means of preserving life, like food and water. But you could withdraw, say, an intubation tube or some sort of treatment that's just voluntary. It's not ordinary. It's extraordinary means to preserve life. At the end of the day, though, the law says that if there's no clear directive, the spouse gets to decide. And so despite the fact that there was overwhelming evidence of Terry Schiavo's belief in the Catholic Church teaching, the judge had to side with the husband, and eventually her feeding tube was withdrawn, and over a period of 2 weeks, she starved to death. Now, I bring this up not to depress you, but I bring this story up because it underscores an important principle, one of the final principles for your estate plan that I think goes overlooked. You don't need, everybody's got a healthcare, not everybody, but people who have healthcare directives usually think, I need to nominate someone who can be in charge of my healthcare decisions. And yes, that's true, but more importantly, you want to turn your wishes into directives. You want to direct your doctors. You want to direct a reviewing court and your family exactly what you want and what you believe about what should happen to you at the end of your life. And as it relates to your children, it's really important for really one very important reason. And when family members fight, again, going back to my time as a litigator, when I see family members fighting over like a healthcare directive type situation, or in a non-healthcare directive, a healthcare directive type situation, when I see family members fighting, it's usually because mom or dad has some sort of condition and they don't agree with whatever sibling is in charge and is making the decisions about the treatment of care. And this is particularly sensitive if the decision is to withdraw life-sustaining measures, right? If you are going to essentially pull the plug, right? That can create a lot of family strife and a lot of family conflict. And the last thing you want to do with your last act on earth is cause your children to be fighting over whether or not this is what mom would have wanted or this is what dad would have wanted. the last thing you want your family to do is be united. And really the only thing that can do that is a healthcare directive that clearly states your directives so that everybody's clear and so that your children are united at that last moment of your death. And so that's why I put that in here. It's really important for kids, especially, to know exactly what mom and dad want. And I think of my own family members, and I think of my own mom and dad. I want to know specifically what they want. So at that moment, me and my sister Amber are going to be united. We know exactly what to do. And that's what a good estate plan will do for you. Okay, so let's get into how you can develop a kids protection plan, because one of the things that makes Regnum Legacy different is we have this method of protecting your kids from all the bad things that could happen in the event of your death while they're under 18. And there's 9 steps. All right, step 1, you've got to choose the right long-term care guardians, and you want to use our sort of non-emotional 3-step process. And here's the process. Number 1, think about what your values are. That's not an emotional statement. It's just a plain, what are your values as a parent? And what values do you want your children to have? Step 2, think about the people in your life who emulate those values. Who emulate the values? Who are the people in your life that emulate those values? And also, who are the people that are closest to your children? Right? So if you're ranking it on a hierarchy, who's going to respect your values the most? And then who do your children like the most or have the strongest relationship with? And then who lives closest, right? So that on a spectrum, you've got the values being respected, you've got a strong relationship, and you've got someone close by. So ideally, you'd have the perfect set of values, you'd have a strong ongoing relationship or existing relationship with your children, and you'd have someone that lives close by so that the children don't have to move to another state or have to move too far away that their life is not that much uprooted. So think about that person. That's step 2. And then the third step is think about all the people who are the opposite. Think about who doesn't emulate your values, who lives too far away. In my case, for example, I love my sister to death, but I wouldn't put her as the guardian of my children or my parents as the guardian of my children because they live in Colorado. And I wouldn't want my kids to be taken from everything they know here and uprooted in such a dramatic way. But I would, and we do, have provisions in our guardianship nominations that require whatever guardian to make regular trips up to Colorado so that that connection to my family is not lost. So you can make those kinds of directives. Okay, so you've done that. You've thought about your values, who emulates the values, and who doesn't emulate the values. Step 2, legally document your choice. Your choice needs to be the person that's closely going to be the emulating the values, who's going to be having an existing good relationship with your children, and somebody who is close by. And document those choices. And equally important, document the choices you don't want. Document the choices you don't want. Step 3, choose the right short-term care guardians. And this can be any family member, any friend that is local. And that means within a 20-minute drive. Who could get to your house at a drop of a hat? If something happened, who could be at your house in 20 minutes? That's who should be the short-term guardian. Step 4, document your choice. Again, most estate plans only plan for the long-term guardian. They put it in a will and they say, in the event of my death, this person should take care of my kids. But no one is thinking about the short term. Who should be the one who takes the kids immediately? And that prevents your kids from going to Child Protective Services. All right, step 5, give your short-term guardians legal documentation and instructions, because when they show up at your house and the police are there, the police are going to need to see some sort of legal document that shows that they're able and allowed to take the children. Step 6, give all your caregivers, that's babysitters, that's Sunday school teachers, that's schools, give them instructions about who to call. If there's an emergency, people need to know where your family are, where they live, and how to contact them. And you need to carry a family emergency ID card. It's a card that we create for our clients that says, I have minor children at home waiting for me. Please call these people. So that if there's an accident, and in this particular case, I'm thinking of a car accident, but it can be any kind of accident, the first responders will see that, because one of the things they do is they go through someone's wallet to figure out who they are and things like that. And the first responders know to check for those kinds of cards. And one of the first things they'll do is they'll know to call those specific people. Next, step 7, you need to tell your long-term care guardians what to do if called upon and where to find your long-term care guardian documents. All right, so they need to know where the plan is. The other thing you need to do is you need to leave them specific instructions about how you want your kids raised and what values and insights and stories you want to pass on to your children. Now, as part of our estate planning process, we have a whole process at Reagan Legacy to develop that story for you, because we believe that one of the best things and the most valuable things about every person's legacy is their unique history, their unique stories. And so we've developed an entire system to document that and pass it on to future generations. But you need to leave that for your long-term care guardians so that they know what to do and they know what kind of stories to tell to keep your memory alive. Step 8, again, exclude anyone you know you would never want raising your kids. Now, you want to do this within reason. For example, I don't want necessarily my family in Colorado to raise my kids, but I wouldn't say I never want them to raise the kids, right? But I can think of a few people that I would never want to raise the kids, and I would put that down. So document that. Step 9, you need to provide enough financial resources, maybe through term life insurance or some sort of savings, and put it into a trust so that not only are your kids protected through life, but the guardian, whoever's that long-term guardian for your children, has access to money to pay for things for them, who can, put them into private school if that's what you want, or who can pay for college, or who can, pay for their ticket to prom or buy them a car, or whatever you instruct, however you want the guardian to use it, put it into a trust so that the guardian has enough money and your children have enough funds to get through it. And again, work with a good, reputable financial planner who can help advise you how to do that. How to get, what term life insurance do you need? Do you need term life insurance? Should you have a mutual fund? But have something planned for that specific purpose. And those are the 9 steps. So let's get to what you can do today to do the right thing for your family. And let's answer everybody's number one question: what should it cost to get the right plan in place? All right, you've got 2 options. You could do it yourself. And I include legalZoom, Rocket Lawyer, get any kind of paper, right? You can get a paper like this and write at the top, estate plan, and just handwrite it out. It's legally enforceable, all right? You can do whatever you want. Go on legalZoom. You can do it yourself. Odds are it's probably not going to work. I've seen countless legalZoom documents fail, and I have to go into court and either rewrite the plan, have the court rewrite the plan, or fix some error in the drafting process. So it's probably not going to work, but you could get a stack of documents, and if that helps you, feel better, then great. You can work with a lawyer. Now, not all lawyers are the same. As I mentioned, you can go to any lawyer. I think I've priced out the lawyers in Southern California. I think the cheapest I've seen is $1,500. Our fees are right about in the middle of, we're not the most expensive, we're not the cheapest. But you can go down the street to a lawyer down here in Ontario or Upland or Chino or Corona, and you can pay $1,500 to get a trust plan. But that's, frankly, and no disrespect to my colleagues, that's probably not going to work either. How do you choose? How do you choose who to work with and what you need? Well, You know you need a lawyer if you own, this is sort of like Jeff Foxworthy, you might be a redneck. You might need a lawyer if, um, you might need a lawyer if you own more than just cars and personal belongings. If you own a house, any kind of real estate, a 401k, a life insurance policy, that kind of thing, you probably should be working with a lawyer. If you want to ensure that the people you love stay out of court and out of conflict, then you probably should hire a lawyer. If you want to avoid probate and estate taxes, you've got to hire a lawyer to do that. It's very hard to do it on your own, and you can mess up so easily if you just have the wrong provisions in place. And finally, if you want to guarantee that your plan will work when you need it to, you definitely need to be working with a lawyer, because only a lawyer can know for sure whether or not that's going to be sufficient to meet your needs and carry out your wishes. All right, this is what I meant by, no disrespect to my colleagues down the street, discount lawyers, and even non-discount lawyers. Frankly, for most of my career as an estate planner, this is how I did it. I was essentially a planning for death lawyer, all right? And so I know from experience that this is how most attorneys work. All right, so here's what the typical experience is like for going to see a lawyer to do an estate plan. It's mostly focused on form documents. You give the lawyer a set of inputs, family history, estate values, beneficiaries, trustees, names of guardians, who you want to be in charge, etc. And they put it into software and it spits out a number of documents. Those documents may avoid probate. I can almost bet that if you died out of the lawyer's office, driving home from the lawyer's office, it's probably going to avoid probate and it's probably going to be okay. The problem happens in the interim between the drafting and the death, because that's where the problems come in. That's where circumstances change. And unfortunately, lawyers like I used to be don't focus on an ongoing relationship with you after you leave their office. Instead, they send you a closing letter saying, thank you, we're all done for you, and we're closing your file. All right. Their form documents are not really going to keep your family out of conflict, because what it focuses on is your money. And that's what I was focusing on. I was focusing on, especially before I had kids, my focus was, how do I get this money to these sets of people as cheaply as possible and with as little tax as possible? That was my focus. After I've had kids, my focus is completely different, and I'll tell you about that in a second. All right. Most estate plans, when you're planning for death, when you go to a lawyer who's solely concerned with planning for your death, most of those plans leave assets to your heirs unprotected. That means they're going to get the gifts outright without any protection and without any conditions. And that leaves it ripe to be pilfered through, either through their own bad choices or creditors, divorces, judgments, bankruptcies. And I think really the key for me is most attorneys that you go to have no ongoing legal guidance or no ongoing legal relationship with you. It doesn't adequately protect your kids because, as I know, even with just a 2-year-old and 3-year-old, your kids change year to year, it seems like. And so your circumstances change, and having that ongoing relationship really helps, because as circumstances change, you may want to increase, right? Instead of getting something at 21, you're going to say, no, they're going to get it at 30 now because I don't trust this guy, right? Your cute 10-year-old's now a teenager, and you're thinking, they're not getting any money until they're 30 because I don't want, you can fill in the blanks there. But if you don't have that ongoing relationship, you can run into problems. So here's how Regnum Legacy is different. I like to look at estate planning now that I have children as planning for life. Not only planning for your own life, but planning for the rest of your life, because we're with you at every step of the way. We charge all flat fees, and best is you get to choose the fee. We tell you, here's the range of fees, and you say, I want to pay that fee. Great, and we'll do it for you. We focus on plans that are going to keep your money out of the hands of the state, and that's going to protect your children, okay? And I like to say that when we're planning for life, one of the things that we're doing as we're planning for life, as we're thinking about life, is we're thinking about legacy. And I mentioned before, I kind of teased it before, that regnum legacy part is where we focus on our estate planning. And that's where you need to focus with your children, is your legacy. Because your legacy is not the money you have. Your legacy is really about who you love and what you love. Your legacy is about the life you have lived. And, you know, we're doing this webinar right now, and for example, Ruth Bader Ginsburg, whether you agree with her opinions or not, most of her legal opinions I completely disagreed with. But nobody can doubt the fact that the life she lived has left a lasting legacy. Nobody is talking about her money or her estate. They're talking about the legacy she left because of the life she lived. So when I'm thinking now, as an estate planner, planning for life, I'm not thinking about how to get your money to your kids after you die. I'm thinking about how to communicate the life you lived to your family members so your legacy is protected. That's what we're thinking about. That's the kind of relationship we're having. And we have a system. Every 3 years, we meet with our clients and give you either a clean bill of health, or we say, you know, hey, we need to work on some things. Circumstances have changed. Let's amend that. Let's bring some different things in. Let's add some different protection and that kind of thing. All right. So if I had to ask you, again, we've touched on this, and let's ask the direct question. If I had to ask you to choose one, you can only choose one thing to leave your children. You could either leave your money, or you could leave your values. You could leave your memories, your beliefs, your stories, and your experience. If you could choose money and property on one hand and values, experience, and stories on the other, what would you rather leave to your children? I know what I would want to leave. And I'm willing to bet, hands down, most of you would want to leave the values. And frankly, as a litigator, when children are fighting in an estate, it's not necessarily about the money. I'll give you an example. We had a case where the 5 kids were fighting over, this was $1 million estate. They were fighting over a ring. Dad had a ring, a ruby ring. It was like a signet ring. It had all these fancy designs on it. And he had got it, I think, in some sort of fraternity. I can't remember the history of the ring. The point is that this was Dad's special ring. And Dad had given it to his eldest son. And the problem is that all the kids wanted it. And so they were fighting over who got this ring. And they were spending thousands and thousands of dollars on attorney fees because they wanted this ring, not because they wanted the property, but because they wanted the memory. And eventually I solved that problem by taking the ring to a jeweler and telling the jeweler, I want 5 exact copies of this ring. And then we mixed them all together. And to this day, none of the kids know who has the authentic ring. The point is, all the kids have a ring that looks just like Dad's, and they were absolutely happy with it. And the reason is because kids don't care about your money. Maybe some kids do. All right, let's be honest. Some kids might care about your money. But by and large, most kids, most of your children, most people's children are going to care about your history, your shared memory together. And that's what makes the property, the money, mean something. That's what makes the home mean something. You shared it together. So we've developed, as I said, a way to pass that on to our families. All right, so what should this cost you? What's it going to cost you? Well, let's talk about what it's going to save you. If you had a $500,000 house, an estate plan is going to save you $26,000. If you have over $11 million in assets, it'll save you 40 cents for every dollar you spend. You can expect, if you're hiring an attorney, to spend at least $1,500 to go with, I call them a death plan attorney. Sort of 80%, 90% of the attorneys out there are planning for your death, not planning for your life. And that kind of plan is not going to ensure that your assets aren't lost to the Department of Unclaimed Property. And the reason is because, and I know this because this is what I used to do, the only property they care about is your home. They ask you, where's your home? They put your home in the trust and they feel like, I'm done. But there's so much more to it than that. And I know that now. All right, the next thing that you need to know about having an attorney who focuses on death planning is that it's just going to cover your money. The attorney's only going to be concerned with what money you have and how to get it to your kids after your death, and they're not going to be concerned with what truly matters, which is the legacy you leave behind. The other way, the other attorney you can go to is my firm, a family legacy lawyer that knows you, that works with you, that's going to be your family lawyer for life, or at least for my life, or for your life. We're going to be together for a while. Point is that you're going to have a family legacy lawyer that's going to plan for your life and prepare your family with your legacy. And like I said, our fees are a range, typically between $2,000 and $8,000, but you get to pick that. We offer financing. You can finance it for $50 or $190 a month. That's if you finance it over 5 years. You can imagine if you do 12 years, it might be different. But the point is we want to make it as simple as possible for families to engage in this planning so we can protect as many kids and as many children as possible. So that's about how much it's going to cost if you go with us. The beautiful part about it is that you can almost be guaranteed that your plan is going to work when you need it. And it's going to continue to work because we're going to continue to have a relationship with you year in and year out. We're going to continually update you, continually be with you throughout this process. And we provide your heirs resources so that they know exactly what to do on your death, which helps the family all the more. All right, let me make it easy for you. Now, if you want to book today, I'm going to put up a link here. You can put a link. How do I do a link? Here we go. So I'm going to put up a link here. It should be on your screen momentarily. It's for our family legacy planning session. We usually charge our clients $750, or if you already have an estate plan, we charge $950 because we have to review the plan and then do a 50-point sort of inspection. Think like you take your car to the service company, you get that inspection. We have the same thing for your existing trust, and we'll tell you whether or not it gets a clean bill of health or not. But we usually charge that between those ranges. We'll give you that session for free. Click the link to schedule now, and we'll give it to you for free. And the other thing that we're going to do if you schedule today is we'll give you a certificate for $750 off whatever plan you choose. So you want to do estate planning with us. We want to make it as easy as possible. We have the financing available, and we're going to give you $750 off, and we're going to give you the wealth planning session for free. That way, at the very least, after that wealth planning session, you're going to walk away not only being more financially organized than you've ever been in your life, but you're going to walk away knowing exactly what you need and how to get there. And so even if you don't hire my firm to get you there, you'll at least have the roadmap so you know how to get there. And that's invaluable for you and for your family. So I'm going to leave you with that offer, and I'm going to ask if we've got any questions. Let me check the chat here. All right, hold on. Let me see. Okay, I've got a question here that Lisa, maybe I shouldn't say, I said it was going to be private. It's not Lisa, it's Bill. Okay, so someone has asked whether or not you can just transfer your estate through deed transfers, right? I think that's what you mean, so deed transfers. So what you're talking about is like, if you would just add your kids to your deed, or do California, at least through the end of this year, is doing what's called a transfer on death deed. That's possible. Here's some problems with it. Number one, if you put your child on the deed with you, like as a joint tenant, what's going to happen is the house becomes legally owned by you, and if you're married, your spouse, and then your child. And on your death, your child would succeed as the sole owner of the house. And that's assuming that's what you want. You want the kid to have the house. The problem is that if your kid is currently married or gets married and gets a divorce, their spouse would be entitled to half of your house. If they got a judgment against them, that person who has a judgment against your child could sell your house to pay for the judgment. If your child ever went through a bankruptcy, the bankruptcy trustee could take your house and pay the creditors with it. And so it does accomplish the goal of giving the property to your children outside of probate, but it bears significant risk that your house is going to be taken from you. Now there's something called a transfer on death deed that allows you to essentially say, on my death, the house goes to my children, whoever you name. It doesn't have to be a child, it could be any beneficiary. And then all they have to do is submit a death certificate with an affidavit stating that they're the person named in the deed and that this person, that you have died, and then the house automatically goes to them. That's a possibility. Again, it's least protective because, number one, it doesn't actually protect your child in the event of, say, a judgment or a divorce or a creditor, as we've already discussed. And the second thing is, if that's your only estate planning tool, it doesn't allow your family to, number one, it doesn't allow you to pass on your legacy to your family. Number two, it doesn't really allow your family to be prepared for example, what your healthcare directives are going to be, or who's going to take care of your child in the short term or in the long term in the event that you die before they turn 18. And it's not going to really protect in the event, you know, for example, if you're currently married, the transfer on death deed would technically go to the spouse, and then from the spouse to the child. Now, in that interim period, that spouse can change the deed at any time. So if that spouse remarries, the stepmom could convince, you know, dad to change the deed to add her to the title, and that effectively cuts your daughter out of the inheritance. So there's some significant risk there. All right, let's look for any other questions. Let's see. Any recommendation for a guardian? Oh, I'm trying to read this. Any recommendation for a guardian out of state? A guardian out of state. Okay, I think what you're saying is that, and correct me if I'm wrong, just type it in the chat. I think what you're saying is that if there is someone that you want to name out of state, are there any recommendations? If that's the case, what I really recommend is doing a couple of things. Make sure that you have a short-term guardian, right, that's local, that can take the kids while the person in the other state, for example, my sister in Colorado. I would need a short-term guardian here in California that could take the kids while my sister booked a flight or drove in that time period while she booked a flight or drove to come down to get the kids. So you can do it, but it has to be documented. It has to be documented that that is your wish, because it's likely that if there's any other option in California, that's where the court's going to go with it, even if you wanted the person to go somewhere else. Okay. I hope that if it didn't answer your question, just type it in. All right. Any other questions? Not seeing any. Bueller. Nothing. No questions for me. Come on, this is your one chance to stump the lawyer. Ask any question. Nothing. Okay. Free legal advice. It's hard to come by. And don't give me any criminal law questions because I can't answer those. I'm not a criminal lawyer. All right. Let's see. There's the dots are moving. Let's see if someone's typing. Okay, here's one. We've got an estate plan. Okay. Okay, so this question is something I think I mentioned, and if I didn't, I should have. The question is regarding you have an estate plan, as I understand it. You have the estate plan, and in that estate plan, you already have guardians nominated. And so the question really is that enough, or what can you do to protect your family further? That's what I'm understanding the question to be. Okay, so most plans, like I said, if you want to go with the death planning attorney, and this is how I would have drafted my plans about 2 years ago, most plans are going to put your guardianship nomination in a will. So in the will, it's going to say, here's how you nominate your guardians. And that's not necessarily the best idea, because in order to get that will to be effective, it's got to go through the probate process, which means it needs to be admitted to probate, which means it's going to take several months before that actually becomes effective. So what you really want are standalone documents. You want your guardianship nomination to be in a separate document that's not in a will, it's not in a power of attorney, it's in its own document. All right. Now that document, if it's, and you can stop me if I'm wrong, if that document is a form document, in other words, it was the form that your attorney gave you, or maybe you printed it off from legalZoom or something like that. If it's a form document, it probably doesn't have any provisions in there about instructions about how you want your children raised after you're gone. So although as a legal matter, a guardianship and a will is perfectly fine and legally binding, it's better to have it as a standalone document, because then it's immediately effective. Well, you're still going to have to show to a court and get a proper authorities with the court, but it's easier than a will. But it's in its own document that's separate from the will, that doesn't have to be admitted to probate. That's my point. And the other thing is that what you want and what the law doesn't require, but what you should have for your family, is instructions about how to raise your children, because that's really the more valuable part for you as a parent. I know it is for me as a parent. I care less about who takes my kids after I'm gone, and I really care more about, are they going to raise them right? Are they going to raise them with my values and with my beliefs and with how I want them to see the world? Are they going to know about my own legacy and my own life in a way that they can be inspired for future generations? Because there's all sorts, especially at a young age. Right now, my kids are so young that I would definitely want something so that they can remember me and can remember what I was about. And maybe, maybe that becomes less and less important as your kids get older. I don't know, but I'll tell you when my kids are older. But what you want to look for is, and what you could do if you wanted to try it by yourself is write a series of wishes about how you want your children to be raised, and give it to that person in the will. Alternatively, you can come to my office, schedule your meeting. You can click the offer link and just say that you have an existing estate plan, and I'll review it. I'll review your plan, your trust, whatever documents you've got. We've got a 50-point sort of inspection list that we go through to make sure everything is working as it should, and to give you peace of mind that, yes, the plan you have in place and the wishes you want and your directives that you want, based on all of that, your plan is going to work for you as it currently sits. So I'd encourage you to go ahead and do that, and then we can have a deeper conversation, because there might be more at play than I just don't know. Okay, let's see here. Anything else? I think I already got that one. Nothing else. All right, we are at an hour, 23 minutes. I'll give it another couple seconds before we close it up, unless there's any other questions. I'm not seeing any. All right, guys, let me just share with you one other thing. And if there's another question in the meantime, we'll go. All right, so here's the next steps. You can claim your gift, register at the link below that you see the offer there. When you schedule, I should say you'll get homework, right? This is, school's back in session, so I'm the teacher and you'll get homework. You'll do your homework and you show up for the meeting. The homework's basically an asset list and a family list, so that I can get to know who your family is, what you own, and then we can strategize at that meeting together. Right? And if you already have a trust, then the homework's going to be, send me your trust and all the information so that I can review it. And then during the meeting, you'll be able to use your $750 off to get a plan with me, or you can think about it or do whatever you want to do. All right. If you have any questions in the meantime, let me check one more time. No other questions. If you got any questions between, say, now and between the next 30 seconds and tomorrow when you wake up and you think, gosh, I wish I would have asked that, this is my email and this is my phone number. Now, you can email me any question you'd like, and I'd be happy to respond to it. In addition, this number on the screen is my business line. So if you called it, my office would answer. But it's also a text line. The texts go directly to my cell phone. So although it's not my cell phone number, any text that goes to my business line is directly to my cell phone, so that if you have any questions or need an immediate answer, you could just text it and I'll just shoot you an answer right back. If it's quick. If it's not quick, I might say call me, or I'll shoot you an email or something like that. But again, if there's no other questions, guys, I want to thank you so much for your attention. I know it's a lot to think about. Number one, your own death. Think about your children's lives without you, and to give me your attention for an hour and 25 minutes and 3 seconds and counting. So give yourselves a round of applause, because I am so proud of you guys for doing this and sticking with me. And more importantly, I am so grateful for your attention today. If you want the replay of this webinar, there will be a replay up. And I believe everybody who's registered will get the replay, so you could replay it if you want. And if you didn't register, if you clicked a live link like on Facebook or something, email me and I'll be able to send you the link to the sort of replay. Or I'll just post it on Facebook and you can just get it there. Anyway, guys, thank you so much, and we'll see you at the next webinar. Have a good one. End.